Hello, my name is Jennifer Huddleston, and I'm a Senior Fellow in Technology Policy at the Cato Institute. I'd like to thank you for joining us at today's online policy forum on what would online age verification mean for speech, privacy, and youth online safety. This policy forum is occurring just mere days after the Supreme Court issued its decision in the Free Speech Coalition v. Paxton case around the questions of online age verification as it relates to content deemed obscene for minors. At the same time, a broader conversation about young people's access to the internet in general, social media, or specific types of content online has been growing both amongst parents as well as policymakers at a state, federal level, and as well as around the world. As a result, needless to say, this conversation is very timely and relevant, as it's important that we consider not only what would such laws potentially mean for young people, but also what would they mean for adult users of the internet. How could we balance potential concerns that parents or policymakers may have around the ways young people might be harmed by content they see online, with ensuring that young people are also able to have the benefits of access to information and speech opportunities online? I'm excited to be joined by an excellent panel of experts for today's conversation, as well as for all of you tuning in. As a reminder, you can submit questions for our panel by using the hashtag Cato Events or Cato Technology, or through the question box that you will find where you are watching this. So I'd like to take a brief moment to introduce each of our panelists, starting with Tommy Berry. Tommy is the director of the Robert A. Levy Center for Constitutional Studies at the Cato Institute. I'm also joined by Graham Dufault, who is general counsel for ACT, the App Association, and by Ariel Fox Johnson, a senior advisor for data privacy to Common Sense Media. Thank you all for joining me today. So to begin with, Tommy, I'm going to go to you. I mentioned that there's been this recent Supreme Court decision in the Free Speech Coalition v. Paxton case. Can you tell us a little bit about the law that was at issue in that case, and what did the court decide, and what might that mean for similar proposals, as well as for the debate over age verification, privacy, and free speech more generally?
Sure, happy to. And thanks for putting this panel together and for having me. So this case was about a Texas law that is similar in many ways to laws passed in about half of the states at this point across the country. And this law essentially said that if you operate a website that's accessible within Texas that has 1/3 or more content harmful to minors, that's the statutory term that was used, you have to put in an age gating procedure. You essentially have to prohibit people under the age of 18 from visiting your website, and you have to put in some sort of hard check, typically most commonly an ID check, to confirm that someone is above the age of 18. So what's content harmful to minors? Elsewhere in the statute, it's essentially defined this as content that's obscene to minors. And here it was piggybacking off a distinction that the Supreme Court has made in several previous First Amendment cases. The Supreme Court has said in general that pornography is protected speech. However, for adults, there's some level of extreme pornography that's so-called obscene, which is not protected by the First Amendment and which you could ban. But the Supreme Court has said that there's a different standard for minors, that if you're a minor, general standard issue pornography that would be protected for an adult is not protected for you. In other words, it's permissible under the First Amendment to ban minors, to ban those under 18 from seeing adult content that would be protected speech if they were over the age of 18. So relying on this distinction, Texas essentially said, if you have 1/3 or more content on your website that's obscene for minors, you have to put in this age gating procedure. This was quickly challenged in a lawsuit by several, both producers of online content and a trade association that represents them, and also actors in this content, essentially making a First Amendment challenge. And what they focused on was not the rights of minors, because that was pretty well established that you can indeed prohibit them from accessing this content, but rather the rights of adults, the people over the age of 18, who now have to show their ID, scan it every time they want to visit one of these websites. Their argument was that there is a chilling factor, that people will reasonably be fearful or nervous about showing their ID and scanning it into potentially an unfamiliar website before they can access this content. The concern is, even if the websites say, we're going to delete your data, we're going to delete the picture of your driver's license, can you really be confident in an era where we've seen the government accidentally leak millions of people's social security numbers? We've seen other hacks, we've seen malware, ransomware. People are just aware that on the internet, it's not always safe to give over personal data. And you can particularly be sympathetic to the notion if someone is, looking at same-sex pornography in a culturally conservative area of Texas where they might not be out publicly, they might be particularly concerned of potential social repercussions. And the Supreme Court has held many times that the First Amendment doesn't just protect your right to access speech, it protects your right not to be chilled in the access of that speech. So this challenge went up, and the Fifth Circuit took a surprising attitude towards the challenge. There were several previous Supreme Court cases dealing with similar federal laws. The most important was a 2004 law called Ashcroft versus ACLU, a challenge to the Child Online Protection Act that was passed by Congress. And in that case, the Supreme Court had affirmed a lower court ruling essentially blocking the law and applying the most rigorous and skeptical form of judicial scrutiny known as strict scrutiny. The Supreme Court in that 2004 case said that there were several alternatives that this federal government had not really considered. Most importantly, putting child blocks on your personal devices, or encouraging parents to put those child blocks on their personal devices. Surprisingly, the Fifth Circuit didn't think it was bound by this precedent. It didn't think it was bound to apply strict scrutiny, the highest form of scrutiny, because the Fifth Circuit argued no one had contested whether strict scrutiny had applied. And in fact, the government had simply made a mistake back in 2004 in conceding that in fact, it should have just been rational basis, like a 60s case dealing with an in-person purchase of nudie magazines, essentially in New York, where an ID check in person had only been subjected to rational basis scrutiny, the lowest and most permissible, essentially impossible for the government to fail level of scrutiny. So the Fifth Circuit upholds the law. It goes up to the Supreme Court. The Supreme Court, in a 6-3 decision, also upholds the law, but by a different rationale than the Fifth Circuit held. In a 6-3 vote with Chief Justice Clarence Thomas writing for the majority, the court applied the middle ground, intermediate scrutiny. It said, we're not going to apply rational basis because this does have some effects on adults' access. But surprisingly, the court again said we're not bound by that Ashcroft versus ACLU precedent. It has a couple reasons why. I wasn't totally convinced by all of them. One is it said it's from the early days of the internet. It said we were just in a weird posture. We were only affirming a lower court ruling. We weren't really diving into whether it was what we would have held. And then finally, it tried, the court in the Paxton case tried to draw a distinction between the actual laws at issue. The law back in 2004 said it's illegal to have adult content, but you can use the fact that you have age gates as an affirmative defense. The procedure was slightly different for this Texas law. It simply it simply said, if you have adult content, you have to have these age gates in. So true enough, the burdens of proof and the procedures were slightly different. But in my view, the upshot of the two laws was virtually identical. You can have adult content, but you need to have an ID check. Yet now, no longer is the standard strict scrutiny. Now the standard is only intermediate scrutiny, and the court held that it easily satisfied that intermediate standard because of the compelling government interest in preventing children's access to this content. There was a vigorous dissent by Justice Kagan, joined by the other two Democratic appointees on the court, which we can get into later. But the upshot is the Texas law has now been upheld, which I think likely means that the similar laws dealing with pornography in about half the states are almost certainly going to be upheld by lower courts as well.
Thank you, Tommy, and thank you for that overview of what has certainly been one of the biggest kind of news elements as it relates to the debate over youth online safety. But of course, this is part of a larger debate. While you mentioned that about half the states have considered this in the particular context of pornography or adult content, we've also seen states and even the federal government considering policies that would be much broader. Laws that either require age verification at an app store level or even at an individual app level. And oftentimes we hear this in the context of social media or in the context of big tech companies like Google or Facebook or Instagram. Graham, I want to bring you into this conversation because ACT, the App Association, works with developers of a range of sizes, but many of them are still those kind of startup small businesses that we think of when we think of kind of the next big thing or the early days of Silicon Valley of, two guys in a garage or really just someone with a great idea. How are your members thinking about age verification laws as it relates to their products that may be more general purpose products? What impact might such proposals have on their business or on their users? And are there things that apps are already doing to help keep younger users safe?
It's a great series of questions, and first of all, I wanted to say thank you for inviting me to join the panel. This is great. I'm glad that Tommy started out with some of the legal backdrop, so you get a sense of what that recent Supreme Court decision means in this context. So we've got some of the legal backdrop here. A little bit about the App Association. We're a trade group, so we're a 501c6. We represent small businesses in the app economy. We do have a size limit, so if you're under the NAICS code definition of a small business, for software developers, it's about $30 million a year. Or the alternative is the OECD definition of a small business. So if you're under 250 employees, then you can be in our membership. But we don't have any limits on the types of companies that can join the membership. And so what you see is a lot of small businesses that are leveraging technology and smart devices to solve problems on behalf of their consumers, their customers, and they span all different industries. And so to give you a little bit of backdrop about what our membership does, what do our members do? I can describe a few different of our member companies to get a sense of the context in which some of these age verification proposals are being evaluated by the members. So one example is SwineTech. So SwineTech is they started out as a maker of a sort of a wearable device for piglets. So it's for piglets to wear, and it'll buzz the mama pig, the sow, if the sow is sitting on the pig for too long, right? apparently, and I didn't know this until I got to know the founder of the company, but it's a really huge issue in pig farming, that there's piglet crushing that happens. And so this member company of ours, Swine Tech, developed a tool to help pig farmers avoid piglet crushing, this really this horrible outcome. And that wearable device, that IoT device, sort of expanded to a software platform that enabled a little bit more features and eventually turned into an app called PigFlow, which is available on the Google Play Store. And PigFlow is basically the back office for pig farming. And you can manage labor, you can manage inputs, and it's basically a really cool and powerful tool to enable you to do a better job of managing your business as a pig farmer. Um, that is a good example of a type of member company that is not focused on providing access to content for kids or providing access to content that is likely to cause age-related risks or present age-related risks, right? Their primary purpose is to help pig farmers solve their problems. They even turned into a mini ISP at one point, providing equipment for connectivity because so few farmers in rural Iowa and Missouri had access to the internet. So they, helped them connect to the internet so that they could then use PigFlow. Another member company on sort of the opposite side of the spectrum when it comes to whether or not and on a daily basis they think about kids' privacy is Rego. And Rego provides a digital wallet for kids. It enables it's called Missoula. It enables parents to create sort of a safe space for their kids to have an allowance, and then the parent gets to approve merchants and approve amounts for each of the merchants so that their kids can have uh, access to a wallet digitally and learn in a really safe environment how to manage finances and the trade-offs that are necessary. Um, Now, Missoula, how do they deal with kids' privacy issues? Um, the main touchstone for member companies that deal with kids or that provide services where they contemplate kids accessing the content, especially those under 13, is the Children's Online Privacy Protection Act. This is the successor law to one of the laws Tommy mentioned, COPA. Um, and the main overarching purpose is to um, cover two types of entities, which are, number one, if you are providing an online service, if you're an operator of an online service that is intentionally directed to kids that are under 13, or if you happen to have actual knowledge that kids are under 13 and using your services, then you have to get verifiable parental consent from the parent of those kids, um, which requires a pretty robust compliance program, right? Now, for Missoula, what they did, like a lot of our members, is they went to a COPPA safe harbor. So under the COPPA statute, third parties can certify that they are provide safe harbor services so that they help other companies get up into compliance with a set of guidelines that they produce. And then if companies are able to certify compliance subject to the safe harbors determination, then they get a presumption that they are in compliance with the underlying law, with COPPA. And that gives a few things. That gives small businesses the ability to come into compliance in a way that they are not afraid that they're going to get hit with like a first offense civil penalty from the FTC. And on the other hand, it helps more companies come into compliance than otherwise would be able to, right? Back to your point about a couple of people in a garage. These are not folks that have big, robust compliance programs, and it really helps to have safe harbors. So another of our member companies happens to be one of those safe harbors, Privo, and they have a suite of tools. They have age assurance tools that help companies that use their services, double check the work and make sure that people are the age that they say they are. And so those tools are available. They're generally the ones that the member companies use if they are focused on providing services to kids. And so if that's your backdrop, right, we have member companies that span the gamut between intentionally focused on providing services to kids and parents of those kids. And then you have services, like apps that provide the back office functions for pig farmers and for restaurants and and scheduling functions for barbershops. Um, the way they sort of evaluate new proposals is that the last thing they want to do is sort of be treated as necessarily needing to be under a COPPA regime. And you mentioned one of the proposals that we're watching, and in fact, 3 states have enacted um, these laws, which would require app stores to send a signal indicating age and require all app developers to receive that signal and therefore have actual knowledge as to somebody's under 13 status. That immediately puts you under a COPPA compliance regime in a way that I don't think policymakers necessarily intend to be the case. I don't think Congress necessarily intended for swine tech to be a COPPA compliance factory, right? What they really wanted to do was create a system that puts parents in control. And so if proposals come out and they take control away from parents or they take away choice, um, then we are going to have some issues with the way those are crafted. We can talk about that. I know we have plenty of time for the panel to get into the details of these proposals, but at a high level, those are sort of the principles that we have to work with.
Great. Thank you so much. And thank you for talking a little bit about some of the different types of companies that are the members of the association. I don't think anyone had learning about piglet crushing on their bingo card for today's webinar.
Yes.
So Ariel, to turn it over to you, I imagine that based on some of your work, you may have a bit of a different approach to this issue than some of the other panelists. I'm curious, what do you see as the role for both public policy and civil society in the youth online safety debate? And how are you viewing the potential trade-offs between values like privacy and speech with the online safety of young people?
So first, thank you so much for having me. I'm a senior advisor to Common Sense Media, and I also teach privacy law and advise on kids' tech policy issues. So Common Sense has long advocated for protecting children and teens online, not keeping them from online spaces, but creating supportive and interesting online spaces where kids can grow and learn and make mistakes. And Common Sense has recently been giving a lot of thought to age assurance, as this is increasingly seen as a way to especially protect children online. I'm using the term age assurance here as an umbrella term that can encompass age verification, which was in the Paxton law, but that also includes concepts like age estimation, age declaration, and other assessments of age that may have varying levels of certainty. So in Common Sense's view, civil society has a huge role to play in the youth online safety debate. It's a multifaceted role. We hear from parents, educators, youth about what they're experiencing online and what they wish they could find instead online. Common Sense educates the community about what's happening in digital spaces and offers digital and AI literacy curriculum to schools across the country and across the globe so that youth are empowered to make smart choices. Common Sense also advocates to try and get businesses, small and big, to do the right thing. That can be a much faster way to get effective protections for youth when it works. If it doesn't, Common Sense also works with policymakers to craft thoughtful protections for children and teens. This can be slower going, especially at the federal level. Increasingly, now that youth online safety and privacy laws are being passed, particularly in states, and you've heard about some of the pending stuff today already, Common Sense and others in civil society are finding themselves busy defending such laws from industry and trade group challenges. So for example, just in the past year, I've filed multiple amicus briefs on behalf of Common Sense in support of different age assurance requirements in cases defending laws with age-appropriate design codes that require privacy protective defaults, or laws that restrict addictive feed product designs. I know that other civil society partners, like Epic is a great example who's long been litigating, have also been busy with amicus work and explaining how it's possible to have protections online and still be consistent with First Amendment principles and protect speech and expression. We've also seen even civil society groups starting to bring cases on behalf of plaintiffs who have suffered harm. So regarding your question about trade-offs, I want to flag first that if the goal is to create a privacy protective space versus, say, an adult or child-only space, you don't really need to have age assurance or age verification. You could just protect everyone's privacy. You could turn off ad targeting by default. You could turn off tracking and profiling. You don't have to have this question of figuring out who is a child and then possibly chilling adults' access to something. I'll note that companies largely seem uninterested in doing this in the US, and therefore, if you do want to protect kids and teens' privacy as a policy matter, even if it's just to provide privacy protective defaults, on a practical level, you're often required to have some sort of way to determine who children are. Common sense has largely been focused on protecting kids' privacy by default and protecting kids' safety through product design changes, such as having algorithmic feeds on social media turned off by default, or limiting late night pings and notifications that can disrupt youth sleep. These are different types of safety protections than the ones that are at issue in Paxton, which, as you just heard, sought to keep kids from seeing specific, adult pornography content and obscene content. As I think we'll discuss more today, they raise different questions about the First Amendment and about privacy and expression. Ultimately, I don't think that privacy and safety are at odds. I think that the business models of maximizing attention and eyeballs and trying to collect as much data as possible on all users and retain that data indefinitely are things that are more at odds with privacy and safety rights.
Thank you for that overview, and thank you for actually bringing up, age assurance versus age verification versus age gates. I think oftentimes we hear all these terms thrown around in these conversations with either presumptions that they mean the same thing or with assumptions that everyone knows what they're talking about. And there's some questions I know in our audience questions that are a little bit related to some of those distinctions that I hope we'll get a chance to dive into. But turning to the whole panel, and Graham, I'm going to start with you with this question. As I mentioned kind of in the introduction, there have been proposals around age verification or age appropriate design or age assurance at a variety of levels of what could be considered the internet stack, from the app store to the apps themselves to kind of these very specific types of content in certain issues. Are there different challenges, advantages, or trade-offs to the approaches depending on where this question occurs of a device level verification versus an app store verification versus an app itself? So Graham, I'll probably start with you, and then Ariel, you're nodding, so I'm assuming you have some thoughts about this as well.
Well, it's a great question. I think, as a general matter, what we want to avoid is sort of lurching forward with policies that are not sort of tailored to the harms that they're trying to address. So if what's at stake is and what is trying to be and what legislators are trying to address is the harms from social media or the harms from sort of that business model that Ariel just described of trying to maximize attention and trying to maximize eyeballs and trying to find a way for government to come in and help regulate or provide tools for parents to manage their kids' access to all that kind of content. Then those kinds of proposals ought to probably be sort of directed to the kinds of platforms that they're thinking about addressing. And one thing that we've seen at the state level and even in Congress now are, and I alluded to this earlier, are efforts at sort of the App Store and the device level to require that everybody be age verified. And so in order to access any app, whether it's PigFlow or Missoula or a remote patient monitoring tool, that you first have to have gone through that process of determining exactly how old the person is, and then the app developer has to know exactly how old they are. So I do put legislative ideas and proposals into a couple of different categories. Some of them are not targeted to the issues at stake and not targeted to the issues sought to be addressed by lawmakers. And there may be reasons that they want to approach it that way. And I think there is some sort of superficial um, attractiveness to trying to put it at one stage in the process, so at the App Store stage. Of course, the problem is that you put everybody that develops an app under this sort of system. Um, the other problem that we see with sort of the App Store focus on, it's called the App Store Accountability Act, is that right now the tools that our member companies have at their fingertips to do age assurance and to provide sort of kid safety features. Some of those are developer tools provided by the app stores themselves. So iOS now has like a sort of a content safety analysis feature where you can, if you have something embedded in your app where you're surfacing content, or you have a messaging component of your app, then they can use that. You can layer that tool over your app so that it reviews it for potential nudity and gives somebody the ability to opt out. Now, developers can do this on their own, but especially small developers, they can use those tools that they don't develop as well, and that are provided by app stores and sort of the software platforms. Right now, those features are designed in a way that tries to serve the consumer, that tries to give parents a choice. Another example is where iOS provides the option to send an age flag to, and this was recently rolled out to app developers. It gives parents a choice to either send the flag all the time, only when asked, or not at all. And so it's presented as a choice to the parent, because the parent is ultimately the one paying for the device and the consumer. So those features are designed in a way that is supposed to meet the consumer's needs. If you layer over that a new layer of compliance that says, well, you actually have to provide the flag in all instances, and all developers have to receive the flag in all instances. That does two things. It takes the choice out of the parents' hands, and it takes the option out of the developer's hands, whether or not they want to have actual knowledge or know exactly how old somebody is when they're downloading an app. And so, what that's part of the reason that you see that all of our member companies, even if they are COPPA compliant and they have kid directed content, they're sort of aligned with the swine techs in our membership in not being supportive of ideas that would put the government sort of in control and in that sort of position of dictating how the software features look, what they have to do, and sort of locking everything into being built toward that compliance rather than being built to serve the customer. We feel like it's not the greatest approach, and so the principles that we have here are, if what you're trying to do is deal with social media issues, make sure that you have a definition that is tied to just to social media, and that we have separate sort of issues with COSA's framework on duty of loyal, or the duty of care. That's pretty strict and broad at the same time. And so we do have some issues with the way that's crafted, but the first threshold question is, are you imposing that on every app, or are you directing that to the kinds of platforms that you mean to sweep in? And then the second question is, to what extent are these proposals taking choice out of parents' hands, looping all developers into COPPA compliance and suddenly having to do age assurance, as Ariel described. Is it requiring everybody to do age assurance, even though that's not really the best use of their time or resources? Or are the proposals looking at things like obscene to minors content, like was the subject of the Paxton versus First Amendment coalition. To me, that decision gives lawmakers a little bit of a path forward. If you can, tailor what you're doing to obscene to minors content, then you have a better path than if you are just subjecting the entire ecosystem to age verification and all the hoops that you would have to jump through and all of the risks that are attendant in requiring information to be collected and stored and compliance shown with age verification regimes.
Gail, as I mentioned, I saw you kind of nodding along as I was asking the question. Do you have thoughts on this as well?
Yeah, thanks. I think, Common Sense's view is that there is a role for everyone in the ecosystem to play in terms of protecting kids, including assessing age. So, and that age assurance in general should be privacy protective, it should be proportional, and it should be equitable. So, I don't think that there is a one size fits all solution or one silver bullet place. There are going to be gaps and holes in protections if you only put age assurance responsibilities on the App Store or on the device or on the operating system. If it's all on the App Store, then what do you do with mobile sites? What do you do with preloaded apps on phones? If it's all on the device level, what about when families are sharing devices? If it's platform by platform and app by app and site by site, how are families supposed to navigate all of this complexity? There's limited research on what parents want in terms of age assurance. But we've seen so far indicates they have preferences for more global or easier to use solutions. And we know with historically parental control technology and parent tools that families are overwhelmed and find these tools difficult to use and often unable to implement them. So while there are different challenges and trade-offs depending sort of on where age assurance falls within the stack, believe that a multifaceted and flexible approach, one that gives parents some choices, but that it's not overly complicated, and that's proportional and protects privacy is sort of the ideal solution, but there's no one place where you're going to solve everything.
Tommy, did you have anything to add on this particular question?
Just a couple points. I would say first, when we're talking about First Amendment issues, it's important to stress that private entities, private app makers, or platform hosts for apps can make whatever choices they want. So the First Amendment doesn't prevent a private app store owner from putting in a policy of like age verification for everything they sell. That's something that is up to individual platform owners to decide. Where you potentially have a First Amendment issue is when the government comes in and says, no, it's mandatory if you're selling, if you operate one of these stores, you have to say put in a minimum age to purchase anything on it, or more specific or more nuanced rules. And I would say then, when I think about the First Amendment questions, it's important to keep in mind the distinction between speech and conduct, or speech and other products that aren't speech. And I think that's what a lot of these, if these are potentially challenged, these types of laws, it's going to come down to those types of questions, which we had a bit of a preview in the Net Choice Supreme Court case from last term, which I'm sure we'll talk about more in this panel, where the court said, we're certain that something like a Facebook or a Twitter or a YouTube is First Amendment protected speech. It's less clear about like an Etsy or an Uber or a Venmo. Like, how does the First Amendment interact with those? Should we think about those as engaging in speech, or about engaging in conduct that happens to be facilitated through the communication functions of the internet? And so the First Amendment questions might be different for those two types of things, which is why these regulations can get tricky if it regulates a mix of them.
Well, Tommy, you brought up some of the other cases that might also be relevant to this conversation, and one of the questions both that I had teed up for our panel, as well as that has kind of come in through the online chat, is there not only have there been a growing number of laws that all have slight distinctions around this question of youth online safety, age verification, age appropriate design. There are also a growing number of court cases in this regard, challenging many of these laws. Can you speak to what we have seen from the courts so far as relates to these more general laws? And are there any particular cases that anyone on the panel is watching for those who are interested in kind of this broader question of the constitutionality of some of these laws?
Wake of this decision, this Free Speech Coalition versus Paxton decision, the first big split we have to make is between the regulation, the laws dealing with pornography and everything else. Because I think we have some clarity now that laws specifically and exclusively targeted at pornography are now under this precedent, whether you agree with it or not, are now almost certainly going to be upheld so long as they draw the line at 18 years old. But what's important to stress is that pornography is the only category of speech where the Supreme Court has held that age makes a First Amendment difference. So thus far, we've never had a Supreme Court decision holding that there are other types of speech, like spicy political speech, or speech that comes up to the line of hate speech but is not hate speech. The Supreme Court has never held that there's a lower bar to prohibit children from accessing this versus adults. And so when we get into any other kind of law that's attempting to put age limits on things like social media or other things related to that, things that some view as harmful to kids' development, we have to start with the important fact that the First Amendment thus far has not been held to apply differently to kids than to adults in that context. That's why, in my view, these laws are so frequently framed not as speech restrictions, but as design restrictions. And again, we get back into that question of, is this a speech regulation or a conduct regulation? So the argument that defenders of these laws make is, oh, this is no different from a faulty product design when we're building widgets or when we're selling toys. We're just trying to tell these social media sites, design your product in a way that's safe for everyone to use. I think that, personally, speaking for myself, I think that's a tough argument to make, an implausible argument to make in the wake of the net choice decision from last term at the Supreme Court, which held that the acts of moderating social media sites by the operators of those sites is First Amendment protected speech, just like a newspaper deciding which op-eds to print and which not. And importantly, just like an newspaper deciding which stories to put on page 1 and which stories to put on page F35, way at the back of the newspaper where people are way less likely to find it. So when we complain or when we say we need to protect kids from addictive practices or algorithms that get them hooked, for better or for worse, those practices are, in my view, First Amendment protected content, no different from a magazine or a newspaper putting the most scandalous or the most attention-grabbing stories on the front page. So a lot of states, I'm particularly following California just because it sets the tone for so much of the modern internet age, for better or for worse. California enacted one of these design codes. Thus far, it's been blocked in part by lower courts. In my view, the most recent lower court decision still did not give as much weight as it should have to the First Amendment interests in designing a social media site as one wants to. But I would say those cases, which are typically, there are a few called Net Choice versus Bonta that are all basically challenges to laws like these, are the most important to follow and probably where a lot of the precedents are going to be set.
And I want to open it up to the rest of the panel. Graham or Ariel, any thoughts on kind of what you're watching going through the courts now, particularly after this recent precedent?
Sure. I guess I agree on a lot of the Net Choice versus Bonta cases being important ones to watch. Probably take a slightly different view than Tommy as to whether all of the product design choices are First Amendment expressive content. I do think that even though Paxton was about pornography, it also talked about other things like, technology changing, and there are some comments and footnotes about facial challenges, and I think it'll be interesting to watch going forward. A lot of these cases have been facial challenges to laws, like how that plays out in the courts. I think whether or not age assurance in any given law raises First Amendment questions is highly fact dependent. So you need a record. It can take many forms, age assurance. It's not always government IDs. It could be facial or hand gestures, which even the dissent in Paxton said was, more privacy protective than giving up your ID. Could be third-party tokens passed through sort of zero knowledge proofs where no one really knows what site you're going to or who you are. And age assurance can be used for many purposes, not all of which are limiting access to content. And if you're not using age assurance for purposes of limiting access to content, but you're using it for purposes of providing higher default privacy protections or for having sort of more protective product design, I don't think that you're in and of itself, the age assurance is not regulating speech in the same way that Paxton's law did. And so the question then becomes, what kind of chilling effect would the age assurance practice have? Which is a different question. And I think post-Paxton that we may see more of an uphill battle for people bringing facial challenges against laws that have flexible age assurance restrictions in place or requirements.
Graham, anything you'd like to add before I move on to some of our audience questions? Graham, we've got you on mute. Don't think we can hear you. Okay, I'm going to go. Without a little bit of technical difficulties at some point. Graham, if you have thoughts when we come back to you on a future question, I'd love you to add any thoughts you might have on what you're watching moving through the courts. I hope our audience won't mind. We had a lot of really great questions come in, and we have only about 15 minutes left in our webinar. So in the interest of time, I'm going to kind of try and group some of them and summarize them together. Ariel, I'm going to go to you first with this one. One of the questions we got is about some of these alternatives to kind of ID verification for age assurance or age verification in some cases. What are some of those alternatives? Also, are there different, and this is to the panel at large as well, are there different questions that may arise around some of those alternatives, things that use biometric information or things like digital IDs that we've seen used in states like Louisiana. So if you could talk a little bit more about what some of the alternative kind of age assurance elements are, and then to you or anyone on the panel, what are some of the perhaps unique or different privacy concerns that might arise from this?
Sure. So, there's a whole spectrum of age assurance, and it can be government ID, which I think is probably like, the hardest verifier, to something like showing that you have a credit card. That's one way under COPPA that you can show that you're an adult. It can be other transactional data, which is something that could be used as a verifier under the Paxton law. Like, do you have a mortgage? Do you have a bank account? Things like that. It could be, do you have history with a cell phone provider? It can be sort of softer transactional data, like how long have you had an email account, or how long have you had social media accounts? If it's a social media service trying to assess age, it could be how old are your friends? What are they posting to you about happy birthday? How many pictures are in your, birthday cake photo, or how many candles are in your birthday cake photo? Different sort of softer things like that. It could be things like scanning your face to give some estimate of your age, and that could be deleted right away, and that could be privacy protective, or also scanning your gestures like your hands. People can check your gait to sort of assess how old you are. The easiest way to sort of figure out age is your sort of self-declared age, and that's what we've often followed on a COPPA regime. How old are you, right? That's the most get-aroundable way to indicate age. But there are a variety of different ways to indicate age, some of which are And I also, sorry, I should have mentioned, with digital wallets, you could indicate your age to a third party site or in other countries like a government, and that could be stored securely on like a digital wallet on your phone. And then when you go to a site, you could share, it could just share yes or no that you meet a certain age threshold and no more information than that. So there are a variety of ways to indicate age, and some are more privacy protective than others, right? Something that just stays on your device and that does not share more information than is necessary, or does not share information with more people than is necessary, or more sites and services, is more privacy protective than, constantly having to upload your passport to every single site. So I think that's sort of something to know and keep in mind, and one reason that we think things should be proportional. I also just wanted to note that, despite what sometimes I feel like I hear industry say, it's not that you're currently always anonymous online. You're often not anonymous online. And this notion that you either have age assurance, and then you're not, or you're anonymous, with age assurance, you'll no longer be anonymous. That's not true. You're not anonymous on social media right now. You're likely not anonymous on whatever news sites or entertainment sites or health sites or adult sites that you're browsing. So the notion that age assurance is going to remove all your anonymity online, I think, is often sort of like a false concept.
Graham or Tommy, I'd like to turn it over to either one of you for any thoughts on kind of, if we're talking about just government IDs, there of course has been Tommy, you kind of talked about this earlier in terms of some of the questions around giving that information up, but oftentimes we hear of, well, could there be alternative mechanisms? Are there particular privacy risks or different trade-offs that you're considering with those other mechanisms like biometrics or anything like that?
Yeah, I can respond a little bit to that. I think there are, like I mentioned, Privo, one of our member companies, does have tools available for age assurance. They do use those transactions methods that Ariel was describing, where you look at how long somebody's had an email account, do they have bank accounts associated with them, all these indicators that the person is probably an adult or is probably not an adult. And so it is nice to be able to have services like that that can handle the back office functions of gaining access to that data, and then sending only the amount of information necessary to the app developer that wants to use the service. So it's a lot of benefits from being able to do that. I also heard mentioned on-device processing. That is a best practice. I think for our member companies, what they try to do is adhere to like data minimization principles and privacy by design, so that they are not sharing information with people that don't need to have access to the information. That if they do have third parties that they're working with to conduct analytics, or if they are plugging into an ad network and providing ads and are ad supported, that they are using best practices to select those ad networks, so that they're not using something that is going to serve something that's inappropriate to kids. So all of that sort of lends itself to an approach where they are going to be using privacy protective methods of determining what age people are, or at least estimating with a high degree of confidence. I also, the last thing I'll mention is that the app stores do provide, and Google just rolled out the zero knowledge proof open API for developers to be able to get basically just the indicator. And again, that's a voluntary. That's a really important aspect of a healthy ecosystem from our perspective. Having a blanket mandate on everybody to do age assurance, everybody to do age verification. Back to your question about which cases are we going to be following. Uh, in addition to what was described, so the Bonta cases, the forthcoming potential challenge to the App Store Accountability Act laws that are now in Texas and Utah, and in Louisiana now, I think, that are if there are folks out there that see the Paxton decision as providing a path for constitutionality for the App Store Accountability Act laws, Bad news, I don't think that framework necessarily applies here. As Tommy was describing, it's a first instance of a determination that age plays a role, and it has to be content that is unprotected by the First Amendment, which is content that is obscene to minors. So we're talking about pornography. And the Abstract Accountability Act laws are not narrowly tailored. They're not tailored to content that is going to be obscene to minors. It's everything. So I we'll be watching those potential challenges that the laws might not be challenged, but I have a feeling that there's probably enough interest in putting up a challenge and making sure that lawmakers know that that's not a great path. So yeah, to answer both of your questions, sorry about the issues earlier.
No worries. Tommy, any additional thoughts on this question? Well, Tommy, I'm coming to you first with the next question anyway, which to kind of group another set of kind of audience questions that we got together. How narrowly or broadly should people understand the Free Speech Coalition v. Paxton ruling? So we had some asking, how well did the court distinguish this from some of the questions around COPA, not to be confused with COPPA, which was a previous law that had faced challenge. Could the underlying question of harmful to minors as opposed to obscene to minors potentially be and understood more expansively? Is this something where there's a potential for this to be interpreted broadly to apply to political content or religious content or other content beyond just kind of the sexual and pornographic context? So I'll start with Tommy and then Ariel or Graham, if either of you want to jump in on this. One second, Tommy, we've got you on mute.
Oh, sorry. There we go. Really important questions. And I think key to stress that although the court had an important decision about the First Amendment level of scrutiny for age gating content obscene to minors, it did not go at all into how to define that. And that's an important question that will continue to be litigated. And there are a few issues in this case that were not litigated. Another one the court explicitly left open is this 1/3 threshold. You have a website that, okay, a lower court finds it hit that 1/3 threshold of content that's obscene to minors. Is the website permitted to cordon off that obscene content, have an age gate just for that, but then be open to everyone for whatever is not obscene to minors, whatever that almost 2/3 potentially of the website might be? In other words, is it allowed to put those into two different categories on the website, only one of which requires access? The Supreme Court said we're going to leave that to the lower courts to decide whether that would comply with the law. And of course, it's a very vague, in my view, difficult and vague standard. What does it mean to be obscene to minors? One of the arguments the ACLU made in challenging this law was, what age are we talking about? Obscene to a 14-year-old is different from obscene to a 2-year-old. The court suggested that we're talking about teenagers, we're talking about adolescents, but the nitty-gritty details, what about sex education? What about advocacy related to transgender surgeries or related to LGBT issues? All of this is undecided by the court's standard. So the hypothetical, once we take as a given that content is obscene to minors, the Supreme Court has held you can have an age gate for that, and it's only subject to intermediate scrutiny, even online. But we have a ton of unanswered questions about applying that on a case-by-case basis to particular challenge content. I would say in general, it's unlikely to make a difference if it's mixed in with political speech. We reached a sort of absurd, there was an era in the 70s where hardcore porn, they would read a Shakespeare sonnet at the end to try to get around the definition of obscenity by saying it had, some cultural relevance. I doubt that that's going to make a difference for the definition of obscene to children, but there's still a lot of unanswered questions.
Graham, do you have any, or Ariel, anything you want to add to this?
I think Tommy, you're right. There is some ambiguity there. Like, how do you draw the line at obscene to minors? And when you're talking about minors, what age are you talking about? But I do think it is a clearer case if your law does not make any distinction at all, that tries to set aside obscene to minors content, and that instead it is an age verification for access at all to the App Store or to the open internet. That you If I were advising a client on this, I wouldn't say hang your hat on Paxton versus First Amendment Coalition to give us a constitutional path. So that's my only addition to it, because I think you're right. There is ambiguity in how you draw that line.
You know, we had a lot of great questions come in. As I mentioned, we're running out of time, but I would like to give kind of each of our panelists an opportunity for a closing thought, as well as an opportunity to share with our audience where they can find out more on about your work, particularly as it relates to this topic, which is certain to be an ongoing debate. So, starting with Ariel, you know, if you had kind of a closing thought on what you most wish parents, policymakers, or judges understood about this issue, what would it be? And also, where can our audience find out more about your work?
Sure. So I think, everyone should look to what's going to happen, as Tommy said, when Paxton starts to be applied outside of the pornography context. There are a lot of unanswered questions there. I agree. I think that child protective laws focused on activities not protected by the First Amendment should not be subject to strict scrutiny. And even if they are, as the dissent in Paxton says, carefully drawn age verification laws stand a real chance of surviving strict scrutiny. I think that's important. I think post-Paxton, we're going to see what is technically possible in terms of age assurance. Whatever level of scrutiny you're applying, we're going to see when companies have to use effective age mechanisms, and when they have a business incentive to make such mechanisms not overly burdensome to their users and privacy protective, because that's what their customers are asking for, we're going to see what companies are really capable of here. I think it's important to remember that digital spaces are the ones in which children are growing up now, where they're learning, they're playing, they're making mistakes. Just as we have protections in the real world, we need to have protections in the digital space, and we need to assess products that kids are using the way we assess products that kids are using offline. Parents want to protect their kids online, but they can't do it by themselves. So companies can and should step up to the plate voluntarily to provide privacy and safety protections to youth. If they don't, I predict that we will increasingly see governments starting to require it. Places where you can find more information about this, Common Sense has a public filings page that has amicus briefs that I've filed on their behalf for age assurance. It also has a white paper on what Common Sense sees as the future of age assurance and how it can exist and protect kids in the US. Thank you again.
And Graham, your kind of closing thoughts?
Absolutely. Well, I tend to agree with some of what Ariel just said, that if companies aren't able to come up with solutions that work for parents, that give parents meaningful choice, that provide just the right amount of information that's actionable, that you're going to see governments step in. And where we land on this issue is that we happen to believe that if what you want to see is better tools, if what you want to see is are tools that work across apps and that work across all the different ways in which your kids are going to access the internet, that the last thing that you want is for the government to design these tools, and that you want an ecosystem where parents are in control, and that they are the ones that developers are creating parental controls for, as opposed to writing the tools for lawyers and for compliance experts. So those are just some parting thoughts, and I think that's I hope that folks are able to take these considerations into account, especially when part of their goal is to ensure that small companies are able to compete with big companies and protect kids along the way. So for more information about the App Association, you can go to ACT Online, ACT Online, there's no punctuation, .org. And there you'll find our blog. We've done a lot of advocacy recently on age verification issues, especially on the App Store Accountability Act, and all of the other issues that our member companies care about and want us to advocate on. So thank you again for having me, and I hope to do this again sometime. Thank you.
Thank you. And last but not least, Tommy, your closing thoughts.
Yep. I'll stress, like the other panelists, we all agree that it's a crucial goal to protect kids online. The only place where there might be disagreement is what's the best means to that end. A government, imposed rules or that tend to be one size fits all, or putting more control in parents with the options to pick from different private choices and different private companies making different offerings about levels of parental control, levels of child access, and so forth. And my view is that, as Graham said, when the government imposes a one-size-fits-all rule for access across all sorts of websites, it tends to be kludgy, it tends not to be the best fit, and it often tends not to recognize that different families and different minors might have different needs. I would say also going forward, I think we should just be concerned about unintended consequences of some of the arguments defending these other age gating things, especially if we're arguing that they're about design and not about the First Amendment, because those precedents won't just be with respect to kids. Those are potentially precedents that would apply to anyone that would allow the government to restrict even adult access. Because, to stress again, the Supreme Court has never held that age makes a difference for things like access to social media or to anything other than pornography. You can visit my page at Cato to see everything I've written about this and other issues. Cato.org. Just search for Thomas Berry on that website. I wrote a blog post about the Paxton decision specifically on June 27th called "A Disappointing Supreme Court Decision Weakens Online First Amendment Protections." So I didn't really play coy with the title, but you can see what I thought about it if you read that.
Thank you, Tommy, and thank you to all of our panelists for what was a great conversation with a good variety of perspectives, really thinking about what is oftentimes a sensitive issue in a very detailed manner. I also want to thank our audience for joining us, and you can find some of my own work related to this topic, like Tommy's, on cato.org. This will conclude our online policy forum, and I look forward to continuing the conversation with you all. Thank you.